Hello, students. Welcome to our lecture on International Covenant on Civil and Political Rights, that is ICCPR, and its provisions. The International Covenant on Civil and Political Rights is a legally binding international treaty that protects basic freedoms essential for individual dignity. It was adopted by the United Nations General Assembly on 16th December 1966 under Resolution 2200A and entered into force on 23rd March 1976. The ICCPR, along with the Universal Declaration of Human Rights of 1948 and International Covenant on Economic, Social, and Cultural Rights 1966, forms the International Bill of Rights. As of 2025, the Covenant has 173 state parties and 6 signatories yet to ratify. Its core purpose is to ensure civil and political freedoms, including the right to life, liberty, equality, and freedom of expression, conscience, and participation in government. The ICCPR transforms moral ideas from the UDHR into binding legal commitments under international law. Every state party undertakes to respect and ensure the rights contained in the covenant to all individuals within its territory and jurisdiction. By making these rights justiciable, the ICCPR represents a global commitment to limit state power and protect the inherent dignity of human beings, regardless of race, religion, or nationality. The ICCPR was developed in response to the atrocities of World War II, when the international community recognized the need for a legal framework to protect human dignity. The United Nations Charter of 1945 first articulated this vision, emphasizing respect for human dignity, human rights, and fundamental freedoms. In 1948, the Universal Declaration of Human Rights set out a common standard for all peoples and nations, but was not legally binding. Consequently, the United Nations decided to draft two covenants, on one addressing civil and political rights, another addressing economic, social, and cultural rights. The drafting process began in 1948 under the UN Commission on Human Rights, chaired initially by Eleanor Roosevelt. It took nearly 18 years of negotiation before the ICCPR was finally adopted in 1966. The covenant entered into force on 23rd March 1976, 3 months after receiving the 35th instrument of ratification. The ICCPR thus represents a you can say post-war consensus that political freedoms and individual rights are universal, inalienable, and indispensable for peace and democracy. It reflects the belief that respect for these rights is essential to prevent tyranny and safeguard human dignity. The ICCPR contains 53 articles divided into 6 parts, each addressing a specific set of obligations and rights. Part 1, Article 1, affirms the right to self determination, recognizing that all peoples have the right to freely determine their political status and pursue their development. Part 2, Article 2 to 5 outlines the general obligations of a state parties to respect, protect, and fulfill rights without discrimination and to provide effective remedies for violations. Part 3, Article 6 to 27, enumerates substantive rights such as the right to life, freedom from torture, liberty, equality before the law, privacy, religion, expression, and assembly. Part 4, Article 28 to 45 establishes the UN Human Rights Committee, composed of 18 independent experts responsible for monitoring compliance through periodic reports and communication. Part 5th, Article 46 to 47, clarifies the covenant's relation to the UN Charter and ensures that it does not limit broader human rights protections. Part 6, Article 48 to 53, governs ratification, amendments, and entry into force. This structured framework makes the ICCPR both comprehensive and enforceable, translating human dignity into precise legal standards for state conduct. Article 1 is one of the most significant provisions in the ICCPR, recognizing the right of all the people to self determination. It affirms that all people have the right to freely determine their political status and to pursue their economic, social, and cultural development. This right applies collectively to people rather than individually to persons. The inclusion of self determination reflects the era of decolonization that followed World War II, providing a moral and legal foundation for independence movement in Asia, Africa, and Latin America. The article further emphasizes that all state parties must promote and respect this right in accordance with the United Nations Charter. The Human Rights Committee has interpreted this article to include both external and internal self determination, meaning not only independence from foreign control, but also participation in domestic governance and democratic decision making uh, at home. Article 1 also highlights that all people may freely dispose of their natural wealth and resources, ensuring that sovereignty over resources benefits the population as a whole. It sets the tone for the entire covenant, establishing that political freedom and self governance are essential prerequisites for the enjoyment of civil and political rights. Articles 2 to 5 define the general legal obligations that every state party must follow under the ICCPR. Article 2 1 requires a state to respect and ensure all rights recognized in the covenant for all individuals without discrimination of any kind. Article 2, Section 3 mandates states to provide effective remedies through competent authorities, including judicial mechanisms for any rights violation. Article 3 guarantees equality between men and women, ensuring that both genders enjoy the same civil and political rights. Article 4 permits derogation of certain rights in times of public emergency that threatens the life of the nation, but only when such measures are strictly necessary and not inconsistent with other international obligations. Article 5 prevents states from misusing the covenant to limit or destroy rights and freedoms beyond what is expressly allowed. Together, these articles establish that the ICCPR binds states both negatively to refrain from violations and positively to take actions ensuring rights protection. They lay the groundwork for accountability, universality, and equality under international human rights law. Article 6 of the ICCPR enshrines the inherent right to life, which is the foundation of all other human rights. Right to life is also called as the mother right. It declares that every human being has the inherent right to life and that no one shall be arbitrarily deprived of his life. This article also obligates states to protect life through legislation and to prevent arbitrary killings, extrajudicial executions, and enforced disappearances. The Human Rights Committee's General Comment number 36 2018 clarifies that the right to life must be interpreted broadly, extending beyond protection from death to include the right to live with dignity. The article further restricts the death penalty, allowing it only for the most serious crimes and under a final judgment uh, by a competent court. It explicitly forbids executing juveniles or pregnant women. The covenant also encourages the abolition of capital punishment, a goal reflected in the Second Optional Protocol of 1989. This second optional protocol seeks total elimination of the death penalty. Article 6 thus establishes the moral and legal foundation for the sanctity of human life, requiring the states to adopt both preventive and protective measures to ensure its preservation. Article 7 of the ICCPR absolutely prohibits torture or cruelty. Uh, Inhuman or degrading treatment or punishments. This right is non derogable, meaning it cannot be suspended even during war or national emergencies. The prohibition covers both physical and psychological torture, including medical or scientific experimentation without free consent. The Human Rights Committee, HRC, has emphasized that states must adopt effective legislative, administrative, and judicial measures to prevent and punish all forms of torture. The article also inspires the United Nations Convention Against Torture, CAT, of 1984, reinforcing its absolute nature. Article 7 is linked to the broader principle of human dignity, recognizing that torture violates the core of humanity. States parties must ensure that law enforcement officials, prison personnel, and security forces are trained in humane treatment standards. The General Comment number 20 of 1992 clarifies that prolonged solitary confinement and corporal punishment fall within the prohibition of Article 7. The covenant thus makes clear that no justification, such as orders from superior or exceptional circumstances, can excuse torture or degrading treatment. This universal prohibition forms a cornerstone of international human rights law, and it is binding on all state parties without exception. Article 8 of the ICCPR abolishes slavery, servitude, and forced or compulsory labor in all forms. It explicitly prohibits slavery and the slave trade, ensuring that no person may be held in servitude. Compulsory labor is allowed only under narrow exceptions such as lawful imprisonment, military services, or emergency public duties. Article 9 protects the right to liberty and security of person, forbidding arbitrary arrest or detention. Anyone deprived of liberty must be informed of the reasons for their arrest and brought promptly before a judicial authority. This article forms the legal foundation for habeas corpus in international law. Article 10 guarantees that all persons deprived of their liberty shall be treated with humanity and respect for dignity. The HRC has repeatedly stressed that conditions of detention must conform to the UN standard minimum rules for the treatment of prisoners, Nelson Mandela Rules 2015. Together, these provisions create a framework ensuring that liberty and personal dignity remain protected even when individuals are lawfully detained. They impose strict duties on states to maintain lawful, humane, and transparent procedures in criminal justice and correction systems. Article 14 of the ICCPR guarantees the right to fair fair and public hearing by a competent, independent, and impartial tribunal. It includes key procedural safeguards fundamental to the rule of law, the presumption of innocence, equality before the courts, and the right to counsel in interpretation. No one may be compelled to testify against themselves or confess guilt. The article also mandates that judgments be pronounced publicly, except in narrowly defined circumstances, such as protecting minors or national security. The Human Rights Committee's General Comment number 32 of 2007 clarified that Article 14 applies to both criminal and civil proceedings where rights and obligations are determined. It further prohibits double jeopardy. No one shall be tried twice for the same offense and ensures that right to appeal to a higher tribunal, fair higher tribunal. Fair trial guarantees are indispensable to democracy and the protection of all other rights under the covenant. Violations of due process, such as secret trials or coerced confessions, are incompatible with Article 14. The provision thereby establishes justice as both a procedural and substantive human rights, central to maintaining public trust in legal institutions worldwide. Article 17 protects individuals from arbitrary or unlawful interference with their privacy, family, home, or correspondence. It requires states to legislate against invasions of personal privacy and ensure effective remedies for violations. Article 18 guarantees freedom of thought, conscience, and religion, including the freedom to adopt a religion or belief of one's choice and to manifest it in teaching, worship, and practice. This right is absolute in its internal dimension. No one may be coerced to adopt or renounce a belief. Article 19 secures the freedom of opinion and expression, including the right to seek, receive, and impart information through any medium. However, this freedom carries responsibilities and may be restricted by law to protect the rights of others, national security, or public order. The General Comment number 34, 2011 clarifies that restrictions must be necessary, proportionate, and non discriminatory. Collectively, these three articles establish the intellectual and moral freedoms at the heart of human individuality. They require states to strike a delicate balance between liberty and social order, ensuring open communication while preventing hate speech and incitement to violence. Article 20 obliges states to prohibit propaganda for war and advocacy of hatred based on nationality, race, or religion that incites discrimination, hostility, or violence. This article complements Article 19 by ensuring that freedom of expression is not abused to promote hatred or conflict. Article 21 recognizes the right of peaceful assembly, allowing individuals to gather publicly or privately for lawful purposes. State States may impose restrictions, of course, only as necessary for national security, public safety, or public health. Article 22 protects the freedom of association, including the right to form and join trade unions. Restrictions must be prescribed by law and necessary in a democratic society. The Human Rights Committee's General Comment number 37, 2020 reaffirmed that peaceful protests are essential to democratic participation and cannot be curtailed arbitrarily. Together, these provisions foster pluralism, civic participation, and nonviolence as foundations for social harmony. The covenant's design ensures that political and social organization remains free from fear, coercion, and discrimination, promoting the collective exercise of individual freedoms. Article 23 protects the family as the natural and fundamental group unit of society, requiring states to safeguard marriage and family life. Article 24 ensures that every child enjoys rights to protection, a name, and nationality without discrimination. Article 25 establishes the right to participate in public affairs, including the right to vote, to be elected, and to have equal access to public service. Article 26 proclaims that all persons are equal before the law and entitled to protection without any discrimination. This article stands independently, guaranteeing equality beyond other specific rights. Finally, Article 27 protects the rights of ethnic, religious, and linguistic minorities to enjoy their own culture, practice their religion, and use their language freely. The Human Rights Committee's General Comment on number 23, 1994 reaffirms that these protections are essential for preserving diversity and cultural identity. Together, Article 23, 22, 27 embody the Covenant's vision of a just and inclusive society, ensuring equality, participation, and respect for diversity. They complete the substantive rights section, linking civil liberties with social cohesion and human solidarity. Part 4, Articles 28 to 45, establishes the United Nations Human Rights Committee, that is HRC, to supervise implementation of the ICCPR. The committee comprises 18 independent experts elected by state parties for 4 years terms. Members serve in their personal capacity, not as state representatives, ensuring impartiality. According to Article 40, states parties must submit periodic reports to the committee describing legislative, judicial, and administrative measures adopted to give effect to the covenant. The HRC reviews these reports in public sessions and issues concluding observations, highlighting achievement, concerns, and recommendations. It also publishes general comments interpreting specific rights, such as number 36 on right to life, number 37 on peaceful assembly, etc. Under Articles 41 to 43, states may recognize the committee's competence to examine interstate complaints, though this procedure is rarely used. The committee meets 3 times a year in Geneva and New York. Its monitoring promotes dialogue rather than punishment, encouraging compliance through transparency and peer review. By creating a standing international body to evaluate human rights performance, the ICCPR transformed global accountability from a moral aspiration into a continuing institutional practice that holds every government answerable before the international community. The ICCPR is supplemented by two optional protocols which expand its enforcement scope. First Optional Protocol 1966. It allows individuals who claim to be victim of covenant violations to submit written communications to the Human Rights Committee, provided their own state party has ratified this protocol. The committee examines admissibility, requests government responses, and issues views, authoritative interpretations, recommending redress. Over 120 states have accepted this mechanism. Second Optional Protocol 1989. This aims at the abolition of the death penalty. It prohibits executions within states' parties and requires them to take all measures to abolish capital punishment. As of 2025, 90 countries are parties. These protocols make the ICCPR a living document that not only defines rights but also creates paths for victims to seek international justice. Ratification of either protocol is voluntary, yet it reflects the highest level of human rights commitment. Together, they strengthen the covenant's enforcement by linking global norms with personal accountability and by advancing the progressive elimination of the death penalty as part of human dignity. Part 5th, Articles 46 to 47, clarifies that ICCPR does not limit the authority of the United Nations under its Charter 1945, nor restrict other obligations of states deriving from international cooperation. Article 46 states that nothing in the covenant impairs the functions of the United Nations or its specialized agencies in promoting human rights. Article 47 emphasizes that all people may freely enjoy and utilize their natural wealth and resources, consistent with the right to self determination in Article 1. These provisions reinforce the harmony between the covenant and broader international law. They ensure that the ICCPR operates as part of an integrated human rights framework rather than as a separate or conflicting instrument. By embedding human rights duties within the United Nations system, the covenant affirms that international peace, development, and justice are interdependent goals. Though its alignment with the Charter, the ICCPR transforms political principles into binding international law, establishing a permanent link between human rights protection and global governance. Part 6, Articles 48 to 53, outline the procedural provisions governing the ICCPR's ratification and maintenance. Under Article 48, the covenant was open for signature and ratification by all UN member states, and specialized agencies. Article 49 provided that mm, it would rather enter into force 3 months after the deposit of the 35th instrument of ratification, which occurred on 23rd March 1976. Article 50 clarifies that the covenant applies to all parts of federal states, ensuring comprehensive coverage. Article, Articles 51 to 52 deal with amendment procedures requiring approval by a majority of states parties and subsequent ratification. Article 53 designates the UN Secretary General as the depository of instruments of ratification. As of 2025, 173 countries have ratified the ICCPR, making it one of the most universally accepted human rights treaties. Its longevity and near global membership demonstrates the worldwide consensus that civil and political rights form the foundation of legitimate government. The covenant's procedural strength, clear accession rules, reporting duties, and open membership ensures its continuing relevance as a cornerstone of international law. ICCPR stands as a landmark in humanity's pursuit of freedom and justice. By codifying fundamental rights, life, liberty, equality, conscience, expression, and participation, it translated moral ideas into binding legal duties. Over nearly 5 decades, the Covenant has guided constitutional reforms, inspired judicial decisions, and strengthened democratic governance across continents. Its monitoring body, the Human Rights Committee, continues to uh, interpret rights dynamically in response to modern challenges such as digital privacy, surveillance, and discrimination. Optional protocols enable victims to seek international recourse, reinforcing accountability beyond national borders. Despite implementation gaps, the ICCPR remains the legal and ethical benchmark for assessing state conduct. It affirms that rights are not privileges granted by governments but inherent to all persons by virtue of their humanity. By joining the covenant, states accept a solemn obligation to uphold these values in law and practice. In a global environment where civil liberties face renewed threats, the ICCPR endures as both a shield for individuals and a standard for nations, a living testament to the universal dignity and equality to humankind. Thank you.